does not avail the respondents in their argument, that the academic board has powers to set up the committee. I'll skip reading out the remaining arguments of this council and move to the crux of the matter. In view of the foregoing arguments, I have taken a careful consideration of the questions raised for determination before this court and the facts opposed to in the affidavit in support. And in opposition to the said originating summons, I have also taken cognizance of the exhibits annexed to the affidavit in support and in opposition of the originating summons. And I find that arising from the totality of the issues raised in the written address in support and in opposition of this originating summons, including the reply on points of law and submissions made in furtherance and opposition of same, the sole issue for determination is whether or not, in view of the facts and evidence before the court, and in view of the answers to the questions raised for determination of this court, the applicant is entitled to the relief sought. In resolving the foregoing issues, I must state foremost that the proceedings initiated by the applicant is one intended to invoke the power of this court to make orders of certiorari and prohibition based on the facts alleged by the applicant in relation to the investigative proceedings carried out by the respondents and the interim report submitted by the second set of respondents. In this regard, I find it apposite to state that the inherent powers of the court to make the said prerogative order arising from provision of section 7 sub 1 and 2 of the National Industrial Court Act 2006, which authoritatively states thus. I'll skip reading out the said provisions of the Act. That said, the nature of the prerogative orders sought by the applicants have been ably described by the court in the case of Judicial Service Commission of Cross River State and another against Dr. Mrs. Asari Young, 2013 citation supplied, where the court held that, and I quote, certiorari is one of the prerogative writs and the order mandamus used by the court to restrain the abuse or misuse of power or to correct errors of law, wrong exercise of discretion by tribunals, public authorities, and government officials. Once a public authority acts judicially or administratively, its conduct is subject to control by the courts by means of certiorari or mandamus. Please see the case of Padfield against Minister of Agriculture, Fisheries and Food, 1968, and the Mystic Limited against Foreign Compensation Commission, 1969, citation to supplied, end of quote, this paroles by what JSC as it then was. In the same case, and in more elaborate terms, the court, per Fabi JSC, as it then was, posited that, and I quote, what really in law is certiorari? It is depicted as follows. Certiorari is one of the prerogative writs whose main function is to ensure that inferior courts or anybody entrusted with performance of judicial or quasi-judicial functions keep within the units of the jurisdiction conferred upon them by statute, which create them. Therefore, an order of certiorari will lie to remove into the High Court for the purpose of being quashed any judgment, orders, convictions, or other proceedings of such inferior courts or body, civil or criminal, made without or in excess of jurisdiction. So please see the case of, see the book from Akinola Abuda of blessed memory in his book, Practice and Procedure of the Supreme Court, Court of Appeal, and the High Courts of Nigeria, 1995 editions, pages 654 to 655, end of quote. With regards to bodies against whom the order of certiorari can be made, the court in Professor Lois Cheluna Nwaboshi and orders against the military governor of Delta State, and orders 2003 citation supplied held that, and I quote, the writ is issued in order that the issuing court may bring the proceedings of the inferior tribunal or court before it for inspection, and if there is due cause disclosed, to quash them. It lies only against the bodies exercising judicial or quasi-judicial authority and in respect of acts performed by them in this capacity, and of course, just per for JSC as it then was. With regards to the prerogative writ of prohibition, the court in the case of Onye Kwelu and orders against the Chief Registrar Kano State High Court, 2014, citation duly supplied, where the Court of Appeal held that, and I quote, in Okukwe against the Federal Board of Inland Revenue, 1974, the Supreme Court held inter alia that an order of prohibition lies to restrain an inferior body or tribunal or body of persons from exceeding its jurisdiction. It is preemptive and preemptory remedy Once the order sought to prohibit it has been issued, as in this case, the remedy of prohibition is extinguished. Please see the case of KC Nigeria Limited against the Commissioner of Police, Supra, and of course, this is per IKEAG, JCA. In reckoning the antiquated nature of both orders of certiorari and prohibition, the court in the case of Zenith Bank PLC against Meridian 2013 citation supplied, where the Court of Appeal held that, and I quote, in R against Electricity Commissioners 1928, Atkin LJ, giving an overview of the functions of the writs of certiorari and prohibition, stated that, I quote, the matter comes before us upon the rules for writs or for prohibition and certiorari, which have been discharged by divisional court. But writs are of great antiquity, forming part of the process by which the King's Court restrained courts of inferior jurisdiction from exceeding the powers. The prohibition restrains the tribunal from proceeding further in excess of jurisdiction. Certiorari requires a record or order of the court to be sent to the King's Bench Division to have its illegality inquired into, and if necessary, to have the order quashed. It is to be noted that both writs deal with the questions of excessive jurisdiction, and doubtless in their origin dealt almost exclusively with the jurisdiction of what is described in ordinary parlance as a court of justice. But the operation of writs has extended to control the proceedings of bodies which do not claim to be and will be recognized as courts of justice whenever anybody or persons having legal authority to determine questions affecting the rights of subjects and having the duty to act judicially, act in excess of the legal authority. They are subject to the controlling jurisdiction of the King's Bench Division in exercising these writs. I'll take that again. They are subject to the controlling jurisdiction of the King's Bench Division exercised in these writs. End of quote. This is Palokulo Shodepe JCA of blessed memory. Bearing the foregoing in mind, the questions before the court by way of highlight is whether the investigation conducted by the second set of respondents leading to the interim report submitted for action upon which the third set of respondents were set up should be quashed by an order of certiorari, while the first and the third set of respondents should be prohibited from bringing into effect the recommendation of the second set of respondents. The respondents, on their part, contended that the first respondents are empowered to set up the committee and that the right of the applicant to fair hearing was not breached, having been invited to appear before the second set of respondents before the final date was presented on the 21st day of September 2019. But inadvertently dated the 10th of foregoing, and the questions formulated by the applicant for determination, I find it apposite to determine whether or not the applicant's right to fair hearing was breached and whether the investigation conducted by the respondents is actuated by bias or malice. In doing so, it is foremost imperative to restate the meaning of a fair hearing, which is not just a constitutional provision as enshrined in Section 36 of the Constitution of the Federal Republic of Nigeria 1999 as amended, but also a settled principle of law. In that regard, the court in the case of Idigbe against Continental Merchant Bank PLC and orders 2016 citation supplied on the meaning of fair hearing, the court in Inakwoju against the delicate citation supplied held thus. The constitutional provision mainly stems or germinates from two common law principles of natural justice. They are Odi Autorem Parem and Nemo Judex in Clausa Sua. The meaning of the Latin maxim, Odi Autorem Parem, is here the other side, here both sides. No man should be condemned unheard. End of quote. When the rule of doctrine, what the rule of doctrine means is that must be given equal opportunities and no even more opportunity or advantage in the presentation of his case. And of course, this particular upon JSC. Drawing from the foregoing and in relation to the instant suit, what is germane is that the applicant should be accorded opportunity to be heard with regards to the allegation made against him, which the second set of defendants made a finding and came up with conclusion and recommendation. This is based on the foregoing that I have evaluated the exhibit next to the affidavits filed by both parties. On the part of the applicant, I reckon Exhibit F is indeed a first interim report of the committee on first semester 2018-2019 diploma results, and at the last page of the said report, the names of the 5th to the 6th respondents, 5th to the 8th respondents, that second set of respondents appear as signatories. I also find that the said report is dated 10th of September 2019, and I have related this date to the narrative presented by the applicant in his affidavit to the effect that he was invited before the committee on 17th of September 2019, where he informed the committee of his ill health. Hence, the matter seems to have been written before he was invited, as he alleged that he was never invited after the first invite. Bearing the foregoing in mind, it will indeed, on the face of it, bear that the applicant's case was indeed before he was invited to the committee via Exhibit E, which is the letter of invitation dated 16th of September 2019. I need to mute all of them. I saw it. What did you press it for?
Just click.
Let's do more. You press something. So where you can mute everybody. All right, please, can you mute yourselves?
Councillor, please mute yourselves. There is noise in the background, please.
Mute yourself. And Obu, it is on record that you are appearing for the respondents, and Amadi is appearing for the claimants, which he announced. So don't worry yourself. It's noted. Mute yourself. Amadi, mute yourself, please. The noise is coming from you. Amadi, mute yourself. Mute yourself, otherwise you will leave the meeting. Amadi, mute yourself.
I'm not even sure hearing anything going on.
He has muted. So it is based on the foregoing. I've evaluated the exhibits before the court. Annexed to the affidavits filed by both parties, on the part of the applicant to reckon that Exhibit F is indeed a first interim report of the committee on first semester 2018-2019 diploma results. And at the last page of the said report, the names of the 5th to 8th respondents, the second set of respondents, appear as signatories. I also find that the said report is dated 10th of September 2019 and have related this date with the narrative presented by the applicants in his affidavit to the effect that he was invited before the committee on the 17th of September 2019, where he informed the committee of his illness. Hence, the report seems to have been written before he was invited, as he alleged that he was never invited after the first invite. Bearing the foregoing in mind, it should indeed, on the face of it, bear the applicant's case was decided even before he was invited to appear before the committee via Exhibit E, which is the letter of invitation dated 16 September 2019. However, the respondent's narrative that the dating of the interim report is 10th September 2019 was an inadvertent error is instructive. Going by the exhibits annexed to the respondents in this regard, the respondents annexed the minute of the meeting of the committee leading to the report as Exhibit 1, 2, 5, and 6. Exhibit 1 is a minute of day 1 of the committee meeting held on the 10th of September 2019, whereby the committee agreed on modalities named the 10 courses investigated, including PAD 111, and the observation made therein before the meeting was adjourned to the 12th of September 2019. What is instructive is that this minute reveals that one of the modalities agreed to be adopted by the committee is the invitation of all the lecturers concerned for interaction. Exhibit 2 is a minute of the 12th of September 2019, and arising therefrom, the closing of the minute reveals to the effect that the committee agreed that before reaching conclusion and making recommendation based on its findings and observations, all lecturers whose basis for assessment revealed the substantial gray areas to be invited for interaction on the Tuesday, 17 September 2019. Consistently so, Exhibit 5 is the minute of the meeting on the 17th of September 2019, whereby the secretary confirmed that all affected lecturers have been invited. This aligns with Exhibit E as tendered by the applicant dated 16 September 2019. Arising from the said Exhibit 5, the interaction between the applicant and the committee was captured in page 6 to 7. And amongst other questions provided by the applicants and dimensions by the applicant that oh my God. The mention by the applicant that he was not feeling well throughout the period of marking was also captured. We makes a consistency with the narrative of the applicant that he indeed appeared before the committee. What is deductible from all of the foregoing is that the narrative of the respondents is most believable, in that the applicants had been duly accorded opportunity for hearing during the session of investigation. Before the session of investigation was concluded, and that the dating of the interim report as 10th is only an inadvertent error. Having been accorded the opportunity to be heard, even by the applicant's own admission, the applicants cannot turn around to allege a breach. This was much of the position of the court in the case of UMA and orders against EFIOM and orders 2013 citation supplied, where the Court of Appeal held that, and I quote, it is settled law that where a party is given ample opportunity to present his case within the confines of the law, but he chooses not to utilize same, he cannot later be heard to complain that his right to fair hearing has therefore been breached. What the court is enjoined by provisions of Section 33 of the 1999 Constitution and as amended to do is to create a conducive atmosphere for the parties to exercise their rights to fair hearing by holding the scales of justice fairly, but firmly, without fear or favor. affection, or ill will. Having provided the required atmosphere, the duty or choice of the party seeking to enforce the civil rights and obligation to utilize the opportunity so created, he cannot be compelled to do so. Where he decides to present his case in an acceptable mode as required by the court and submissions, and he would be heard. On the other hand, where he chooses not to present his case, he cannot later be heard. I've asked you to mute yourselves. You have no business coming for a judgment. You cannot mute yourself. You can leave. Where he chooses not to present his case, he cannot later be heard to complain that he was not heard in the instant case. End of quote. This per OTC JCA. With regards to the allegation, I need something heavy to come behind it. That heavy book, red one. With regards to the allegations of bias predicated on the fact that the applicants instituted a case against the respondents to challenge the setting up of a committee to investigate a petition against him, I've taken a look at entire proceedings as conducted by the respondents with regards to the investigation of results, and find that the investigation was also against 8 other lecturers and not just the applicant. Hence, there's no particularization. More so, this court is not necessarily to determine the correctness of the finding of the committee, but simply to review the procedures adopted, that notwithstanding upon the evaluation of Exhibit 3 and 4 as annexed by the respondents, particularly the altered and ridiculously inflated final scores for 5 students, I find that there is indeed a genuine basis for investigation without any actuation by bias or malice, and there need not be a petition or call for remark before the first respondent's institution can review the results that its appropriate organ will improve. If there is a provision for the law establishing the first respondent, which stipulates that there must be a petition before results are reviewed, then the applicant is under an obligation to proceed before placing reliance on it to establish a case of bias or malice. In addition, the allegation of personal attacks leveled against the second respondent by the first respondent is also unsubstantiated and can in no way be a total, I take that again, can in no way be a tool to clog the investigation, which has a genuine basis and prima facie case. In the light of the foregoing, I do not find any case of breach of fair hearing, nor actuation of investigation by malice or bias. Accordingly, question 1 is formulated by the applicant in its answer to the effect that the proceedings of the second set of respondents in relation to the applicants indeed complied with the requirements of fair hearing. Consequent upon the answer to the question 1, it is axiomatic that the answer to the questions 2 and 3 are answered to the effect that an order of certiorari and prohibition cannot lie against the report of the second respondent, and the respondent is not in any way prohibited from conducting further investigation against the applicant in relation to the result of diploma students of the first respondent. Questions 4 and 5 are also answered to the effect that while it is found that the procedure on the second set of respondents is unflawed, then the first set of respondents can take steps to implement the findings and recommendations contained in the report of the second set of respondents, including setting up the third respondents. Consequent upon the answers to the questions formulated to the applicants, as reflected above, the sole manager, I'll take that again, the sole issue formulated for the determination of this suit is resolved to the effect that the applicant is not entitled to any of the relief sought. In the final analysis, the case of the applicant's lack merit in its entirety, and all the relief sought are accordingly dismissed, judgments accordingly entered, and make no order as to cost.
Well, we are most grateful for the well-considered judgment.
You are welcome.
And we are grateful for the well-considered judgment.
You are welcome. Supposed to be charging this. All right, so we take the next case. So, promise, are the defendants here
Yes,
now?
my lord.
This?
Hello?
Defendants in court now for your case?
My lord, I don't know who the defendant lawyers have.
Not here. The defendant is here.
All right, so we take your case next. Okay?
Yes, my lord. We are ready.
NICN.
Yes,
My lord,
go
should I
ahead.
call the matter?
Yes, please.
NICN stroke PHC stroke 128 stroke 2019 between Comrade Precious B. Nani and one other and Comrade Franklin Ajinwo.
All right, so Promise is here for the claimant. Where is the other
Yes, my
counsel?
lord.
The other counsel? I beg your pardon?
AS who will not appear for the defendant, UHUO is the surname.
Your name again, because I don't have that name on my records.
I'm so sorry, ma'am. AS UHUO.
AS.
Yes, ma'am.
UH.
Mrs. Steven Uho. Yes,
UHU.
UHU. Yes, my lord.
Okay. You are for the
Must appear
defendant?
for the defendant. Yes, my lord.
All right,
Most
thank you.
grateful. Thank you, my lord.
All right, so here's the judgment of the court now. The claimants commenced this suit by way of originating summons on the 21st of October 2019 and supported same with a 22-paragraph affidavit deposed to by Augustine K. Banigo with a written address. The suit was originally before Honorable Justice N.C.S. Oguaya before same was reassigned to the court sometime in 2023. Arising from the originating summons, the claimant seeks for the determination of the following questions. I'll skip reading out the questions. And upon a resolution of same, the claimants are seeking for the following reliefs. are seeking for the following reliefs. I'll also skip reading out the reliefs because of the network problems we've been encountering, so we can quickly get through. I still have one more judgment. And reacting to the originating summons, the defendants on the 12th day of November 2019 filed a 16-paragraph counter affidavit deposed to by one comrade Franklin and Jimo, along with a written address in opposition. Upon receiving the counter affidavit, the claimants on the 25th day of November 2019 filed a further affidavit of 12 paragraphs, as well as a reply on points of law. Arising from the affidavit in support of the originating summons, the highlights of the fact leading to the questions for determination and relief sought by the claimant is that the deponent posited that defendants are the immediate past state executive council members of the Nigerian Union of Local Government Employees, Rivers State chapter, while named defendant Comrade Franklin Ajewo, is it complete? She said, while Comrade Franklin Ajewo is the immediate past president of the NULGE Rivers State chapter, whose tenure expired on the 17th of October 2017, having served for 4 years counting. Counting from 18th of October 2013, when they were elected into office as Rivers State chapter executives of the NULGE. The claimants added that the defendants refused to vacate their office after the expiration of the tenure, despite the judgment delivered on the 11th day of July 2019 by the National Industrial Court sitting in Owerri in suit number NICN OW 36-2018 between Comrade Uzoma Ekianyawu and others against Comrade Pastor Richard Eze and 2 others, which formally nullified the resolution of tenure elongation made in favor of officers at the NULGE nationwide in 2016. The claimants also added that by the reviewed NULGE Constitution 2005, which was in operation when defendants assumed office in 2013, the NULGE amended Constitution 2016, the tenure of office for elected officers of the NULGE at the national and state level is and remains 4 years, which could not be elongated to 6 years. The claimant posited that the defendants deliberately and blatantly refused to obey the judgment of a court of competent jurisdiction and refused to hand over the keys to the state secretariat of the NULGE to be appointed caretaker committee led by Comrade Pastor Tobins Tamunong Tonye, thereby creating unnecessary tension and avoidable rancor at the state secretariat of the NULGE, hence this action. In reaction to the foregoing and arising from the counter affidavit filed by the defendants deponent posited that the claimants are suspended members of the union at their local branches as they were suspended for gross misconduct and anti-union activities. The defendants posited further that the tenure of the office of the present Executive Council of the Nigerian Union of Local Government Employees was to end on the 18th day of December 2019, as the named defendant was first elected for the first time in office in 2009 and was re-elected for another 4 years in office in 2013. And the tenure of all the elected executives from the national, state, and the local government branches nationwide were extended for 2 years across board at the Special National Delegates Conference held on the 13th of October 2016. The defendants maintained that the decision of the National Industrial Court in suit number NICN OW 36-2018 between Comrade Uzoma Eke Anyawu and 2 others against Comrade Pastor Richard Eze and others did not notify the decision of the Special National Delegates Conference concerning tenure elongation of the executive members led by the defendant of Rivers State, and that the State Executive Committee led by the defendant on record was not a party in the suit and no pronouncement was made against the National Executive Committee and defendant-led executive. The defendant added that the National Industrial Court, Abuja Judicial Division on the 8th day of August 2019, in suit number NICN ABJ 235M 2019 between Comrade Utoma Ekwanyawu and others against Comrade Pastor Richard Eke and others by a motion experte filed by the same claimants in suit number NICN OW 36 2018, seeking for the interpretation of the judgment of the Honorable Justice I.S. Galadima delivered on the 11th day of July 2019 in suit number NICN OW 36 to the effect that the judgment of the Honorable Justice I.S. Galadima aforesaid shall be construed to read as limited to the Imo State branch. The defendants also posited that this suit is an abuse of court process and the court has no capacity to grant the relief sought. I reckon that the claimants countered some of the assertions made by the defendants in the further affidavit, and same will be considered in the course of determination of the questions for the court. Arising from the written address filed on behalf of the claimants' counsel, I'll take that again. Arising from the written address filed on behalf of the claimants, counsel to the claimants, A.A. Abo Esquire, formulated 2 issues for determination. I'll skip reading out the arguments of this counsel. And reacting to the foregoing, counsel to the defendant, A.A. Brown Esquire, through the written address filed in opposition, formulated 3 issues for determination. I'll also skip reading out the arguments of this counsel. Then there was a reply on point of law, which was filed on 25th of November 2019. I also skip reading out the arguments contained therein. So in view of the foregoing arguments, I have taken a careful consideration of the questions raised for determination before this court and the facts opposed to in the affidavit in support and opposition of the originating summons. I've also taken cognizance of the exhibits annexed to the affidavit in support and opposition of the originating summons. I find that arising from the totality of the issues raised in the written addresses in support and opposition of the originating summons, including the reply on point of law and submissions made in furtherance and opposition of same, the sole issue for determination of this suit is whether or not, in view of the facts and evidence for the court, and in view of the answers to the questions raised for determination of this court, the claimant is entitled to the relief sought. In resolving the foregoing issue, I find it apposite to foremost address the contentions touching on the jurisdiction of the court as raised by counsel to the defendants via the written address in opposition of the originating summons. This is because it is beyond conjecture that where a court lacks jurisdiction, an adjudicatory proceeding, no matter how brilliantly conducted, ends up a nullity. In the case of Ardo against another and Nyakwa against others, 2013 citation supplied, the Court of Appeal held that, and I quote, "It is right that jurisdiction is a fundamental and threshold matter, the lifeblood of adjudication, which when raised, the court ought to determine same before proceeding with the consideration and determination of the substance of the case. Where a court lacks jurisdiction to entertain a suit and the entire proceedings is a nullity, no matter how well conducted." It has also been held that it is the claim of the plaintiff, in this case, it is the statement of claim and relief sought by the appellant that determines the jurisdiction of the court. Please see the case of Inad Koju against Adeleke, 2007 citation supplied. End of quote. That said, I reckon foremost that counsel to the defendants contended that the claimant lacks local standing to sue because they are suspended members and have not shown any interest in the subject matter, while XBC was not signed nor authenticated. In reaction, counsel to the claimants posited that the claimants were never suspended as they have never been served the letter of suspension, while Rule 5 sub 4A of the NULGE Constitution amended 2016 accords the claimant's local standard. The council also adds that the Exhibit C is not in the category of documents that require signature. Consequent upon the foregoing, I must foremost state that the issue of local standard is indeed linked to the issue of jurisdiction, and the court in PDP against the Dede 2022 citation supplied has in this regard held that, and I quote, a cause of action and standing to sue are linked to the issue of jurisdiction of a court if the plaintiff has no cause of action or standing to sue, that is local standard, to institute an action, the court cannot properly assume jurisdiction to entertain them. Please see Arowolo against Akayeyo 2012 citation duly supplied. The court also posted that to determine whether or not a party has a standing to sue, the court must look at his originating summons and the affidavit in support of it. This is per Burka JCA. For the avoidance of doubt, the court in the case of Ayorinde against Kufuruji 2022 citation supplied, the Supreme Court held that, and I quote, local standard denotes the capacity of the plaintiff to institute proceedings in a court of law to seek a determination of his civil rights against the defendant. Please see Lade Jobi against Oguntayo 2004 citation duly supplied. Bearing the foregoing in mind, it is instructive to mention that by paragraph 4 of the affidavit in support of the originating summons, the claimants averred to the effect that the suit was instituted on behalf of the aggrieved members of the NULGE owing to the defendant's breach and abuse of the NULGE constitution by refusing to vacate office after the expiration of the tenure in office. To start with the issue of whether the alleged suspension of the claimants affects their capacity to institute action in that regard, I reckon that defendants exhibited 2 letters of suspension as Exhibit A and A1 respectively, issued to the claimants. The said letters were dated 26th of August 2019 and the 4th of September 2019. That said, the said letters truly as contended by counsel to the claimants bears no acknowledgement of receipt by either the counsel, of the counsel, and holds no weight in view of the fact that the claimants exhibited the deduction of their union dues for the months of August and September 2019 in the case of the first claimant, and August, September, and October in the case of the second claimant. It is also instructive to state that the person suspended does not entirely lose his membership, and the suspension does not preclude such member from contending for his right before a court of law, including the proprietary or otherwise of the suspension. More instructively, I have taken into account the rules or the provisions of Rule 55A of the Constitution of the NULGE as amended and annexed as Exhibit B, which states that any member shall have the right to initiate action at his or her own expense in connection with any breach of the provisions of the Constitution, provided that an appeal to the higher organs have been made and determined before such an action could be initiated. Bearing the foregoing in mind, it is instructive to state that where the words of the statute is clear and unambiguous, the court does nothing more than to give effect to it accordingly. Having resolved that the membership of the claimants with the NULGE is unchallenged, the claimants have the right to initiate the instant action, which was to contend the alleged breach of the union constitution by the defendants. With regards to the status of Exhibit C, being an unsigned document as one of the bases for contending that the claimant lacks local standard, I must state that such argument is of no moment, particularly upon evaluation of the said document. Exhibit C, as annexed by the claimant, is a tabulated document stating the date of the last election and constitutional expiry dates bearing 37 rows for all 36 states, chapter, and the FCT. It is this said document that the defendant posited was not authenticated to have emanated from the NULGE. Assuming the said document in any way is not authenticated, such will only go to the weight and not necessarily become the basis for contending local standard of the claimants whom the court have found to indeed be members of the said NULGE and has capacity to challenge a constitutional breach and abuse by other members. In the light of all of the foregoing, the arguments with response to the lack of local standard lacks merit in its entirety and same is accordingly dismissed. The second ground of contention that this court lacks jurisdiction is predicated on the fact that the suit is an abuse of court process owing to dependency of suit number NFCN 108, 2019. Counsel to the claimant in reaction contended that the parties and subject matter in suit number NICN PH 109 is different from the instant suit. Hence, the principle of abuse of court process is inapplicable. In resolving the foregoing contention without much ado, it is not in doubt that abuse of court process can impinge the jurisdiction of the court, and the various ways an abuse of court process can occur was made manifest in the case of Benke against R. Benke Nigeria Limited against Cadbury Nigeria Limited, 2012 citation supplied, where the Supreme Court held that, and I quote, the concept of abuse of court process relying on numerous decided authorities is imprecise. It involves circumstances and situations of infinite variety and conditions, but a common feature of it is the improper use of judicial process by a party in litigation to interfere with the issue of administration of justice. The circumstance which would give rise to abuse of court process include instituting a multiplicity of action, on the said subject matter against the same opponent on the same issues, or on multiplicity of actions on the same matter between the same parties, even where there exists a right to begin the action. Instituting different actions between the said parts, between the same parties simultaneously in different courts, even though on different grounds, where two similar processes are used in the exercise, in respect of the exercise to the same right, for example, a cross appeal and the respondent's notice, where an application for adjournment is sought by a party to an action to bring the application to court for leave to raise issues of fact already decided by the lower courts, where there is no law supporting the court process, or where it is premised on frivolity or recklessness, where a party has adopted a system of of forum shopping in the enforcement of a conceived right. Lastly, G, it is an abuse of court process which is already subject of an earlier application by the respondent at the Court of Appeal when the applicants has the, or when the appellant's application has the effect of overreaching the respondent's application. And lastly, where two actions are commenced. The second one asking for a relief, which may not have been obtained in the first. The second action is prima facie, vexatious, and an abuse of court process. End of court is Adekeye JSC Ashidan was. Whichever the instance of abuse of court process is alleged, it is imperative for the court to make a comparative analysis of these two situations before the court to determine which constitutes an abuse. In an attempt to make the said comparative analysis, I have perused the entirety of the processes filed and the documents exhibited before the court by both parties. I find that the processes for the alleged suit number NICN PH3 PH 109/2019 which could clarify the similarity of difference between the both suits is not exhibited. And upon failure to do so, it is practically impossible for this court to determine the questions of abuse of court process upon the basis which it was alleged. Consequently, the contention as to the court abuse of court process lacks merit in its entirety and is hereby dismissed. Having resolved the preliminary issues with regards to jurisdiction, I then turn to the substantive suit, which is clearly in relation to the tenure of office of the defendant. Led ESCO, which the claimant alleged ought to have expired on the 17th of October 2017 by virtue of the provisions of Rule 5, Sub 2, Rule 10, Sub 1, and several others of the NULGE amended Constitution 2016, Reliefs 2 and 3 of the judgment of the National Industrial Court delivered on the 11th day of July 2019 in suit number NICN OW36/2018. The foregoing suggests that this court is called upon to consider the provisions of the Constitution of the NULGE and the earlier decision of this court in determining the tenureship of the defendants. Bearing the foregoing in mind, I must state that the canon of interpretation that must foremost be applied in the interpretation of an instrument is the literal interpretation. And it is settled beyond conjecture that the courts do not engage in drafting or redrafting, but merely to interpret. In a detailed exposition, the court in the case of Corporate Affairs Commission against United Bank for Africa PLC and others 2016, citation supplied, the Court of Appeal posited with regards to the disposition of the court in relation to statutory interpretation when the court held, and I quote, it has been said, as a matter of fact and law, that the primary duty of a judge is to expand and not to expand the law. In any case, the fundamental duty of court is to bring to fore the intention of the legislature as expressed in a statute and nothing more. In Amechi against INEC 2008 citation supplied, Mohammed JSC stated that, and I quote, "It is certainly not the duty of a judge to interpret a statute to avoid its consequence. The consequences of a statute are those of the legislature and not the judge. A judge who regiments himself to the consequences of a statute is moving outside the domain of statutory interpretation. He was, by that conduct, engaged himself in morality which may be against the tenure of the statute, and therefore not within his judicial power." Similarly, Galadima JSC reiterated in Aromalaron against Agoro 2014 citation supplied, where the Supreme Court held that, and I quote, "I must say, the duty of the court is to interpret the words contained in the statute and not to go outside the clear words in searching for an interpretation which is convenient to the court and to the parties in the process of interpretation. The court will not embark on a voyage of discovery. Where a statute is clear and unambiguous, as this case, the court will follow the literal rule of interpretation where the provision of the statute is clear and no more. In the case of Adewume against AG Ekiti's 2002 citation supplied, while the JSC of blessed memory said at page 512, and I quote, "In cases of statutory construction, the court's authority is limited. Where the statutory language and legislative intent are clear and plain, the judicial inquiry terminates there." End of quote. This part of Obaseki Adejumo, JCA. Streaming from the foregoing, I've taken due cognizance of the provisions of the Constitution of the NULGE as referred to by the claimants and find it imperative to reproduce the said rules in relation to the issue of question. In relation to the issue in question. In this regard, I find Rule 13 sub 6A of the 2005 Constitution relevant, as same was in place at the time the defendants were elected into office in 2013, and Rule 21 sub 4A of the 2016 amended Constitution. The Rule 13 sub 6A of the 2005 Constitution provides thus, I'll skip reading out the provisions of the said rules. Chicken back on. As rightly stated by the learned senior counsel for the appellant, the golden rule of interpretation of statutes is that where the words used in a statute are clear and unambiguous, they must be given their natural and ordinary meaning, unless to do so would lead to absurdity or inconsistency with the rest of the statute. It was held inter alia in the case of Ibrahim against Birthday, 1996, citation supplied, per always CJN as then was, that if the words of the statute are precise and unambiguous, no more is required to expound them in the natural and ordinary sense. He held further that the words of the statute alone in such circumstances best declare the intention of the lawmaker. Please see the case of Ojo Kolobo against Alamu 1987, citation supplied. Uwazurike against the Attorney General of the Federation, 2007, citation duly supplied. It is important to note that the caveat to the literal construction of statutes as stated in the authorities referred to above is that such literal interpretation must not lead to absurdity or inconsistency with the rest of the statute. End of quote. Is particularly upon JSC. While it is clear that arising from the provisions of the NULGE Constitution, the tenure of office of state officers of the NULGE is 4 years, the defendant presented a narrative to the effect that the second tenure of 4 years of the defendant was extended by 2 years to come to an end in the month of December 2019. The defendant posited that the extension was effected at the Special National Delegates Conference held in Akure on the 13th day of October 2016, and as required by the Trade Unions Act, the Federal Ministry of Labor and Employment was informed of the decisions by a letter dated 13th December 2016. The defendants accordingly posited that the tenure will end or has ended now in December 2019. Bearing the foregoing in mind, I have taken a look at the exhibits annexed to the defendant's counter affidavit and find rightly so that Exhibit B is a certified true copy of the minutes of Special Delegates Conference of the NULGE held on the 13th of October 2016. And the said conference under motion 1 is reported to have unanimously resolved for the extension of the tenure of the president of the present elected officers of the union at all levels by 2 years, with effect from the expiration of their tenure. Exhibit D on its part is a letter written by the Federal Ministry of Labor and Employment dated the 13th day of December 2016, arising from which the ministry conveyed the acknowledgement of the resolution and that the constitutional amendment will soon be approved of all the requirements, if all the requirements are met. There was, however, no exhibition of the said approval if it ever came. It is upon the evaluation of the position of both parties in the suit that I have taken another consideration. Another consideration of the relief sought in the instant suit, particularly as it relates to the tenure of office of the defendants, which the defendants posited that same will and must have now come to an end since December 2019. I've also taken cognizance of the fact that the defendants annexed exhibits G1 and G, which contains notification that the SAC leadership will expire on the 18th of December 2019. While exhibit 62 bears notification for nomination forms for offices to be contested for with intent to swear new leaders by the said 18th of December 2019. Okay, so I'm back in the meeting. Sorry for the break in transmission. So what I've deduced from the foregoing state of affairs vis-a-vis the instant suit and the relief sought is that the suit has become spent and academic, and its determination will not serve any utilitarian value to the claimants. In the case of Shetima and another against Gwani and others, 2011 citation supplied, the court held that a suit is academic where it is purely theoretical, makes an empty sound, and of no potential or of no practical utilitarian value to the plaintiff, even if judgment is given in his favor. A suit is academic if it is not related to practical situation of human nature and humanity. End of quote. Please see the case of Plateau State against Attorney General of the Federation, 2006, citation supplied, end of quote. This per Unguta JSC of blessed memory. Also in the case of Uchegbu and another against Ngbia Horoke and others, 2017 citation supplied, the Court of Appeal stated that, and I quote, a case is said to amount to an academic venture where there cannot be said to be live issues in litigation if what is represented to the court for a decision, when decided, cannot affect the parties thereto in any way, either because of the fundamental nature of the relief sought or the changed circumstances after the litigation started. So that in the end, an appeal has become academic at the time it is due for hearing. Please see the case of Attorney General of the Federation against AMPP, 2004 citation supplied. This is per Umbamba JCA. Bearing the foregoing authority in mind, I must recount once more that this suit, which was instituted in October 2019, was originally before my learned brother, Honorable Justice N.C.S. Ogbanya, and upon perusal of the record, I found that the matter came up for the first time on the 11th day of December 2019. It was adjourned to 26th day of March 2020. It is no news that it was within the set period that the world suffered the breakout of the COVID-19 pandemic, which put a halt to judicial proceedings. The matter returned to hearing on the 25th day of May 2022, and on the said date, the claimants withdrew the application for interlocutory injunction, while parties were not able to adopt their processes before same was transferred to this court. The implication of the intermission between 2019 and 2023, without a doubt, has told a great deal on the nature of the relief sought by the claimants, and even though parties still proceeded to adopt their processes for the court, an evaluation of the reliefs clearly shows that it has become academic, because the relief seeking for an order of injunction restraining the defendant from administering, managing, controlling the activities of NULJE, including collecting checkup dues in Rivers State, will be of no effect if the said defendants are no longer in office, since the defendants posited that the evidence that their tenure expired since 2019, over 3 years ago. And there is no such amendment of fact stating that defendants are still in office at the time of adoption of the processes for this suit. So where a suit has become useless, has become academic, the court has no jurisdiction to entertain such a suit, as it lacks jurisdiction to entertain academic questions and questions that have no practical value. Please see the case of Elendo against INEC and others, 2014 citation supplied. Consequent upon the foregoing, it is the finding of this court that the instant suits have become academic. This court lacks jurisdiction to entertain the instant suits, and same is accordingly struck out. The judgment is accordingly entered. I make no order as the court. All right, thank you.
As copies, I'm deeply grateful.
No, grateful for a well-researched judgment.
Next case, please.
My judge.
Yes.
Aja Sylvia. Respectfully, my lord. Aja Sylvia. The suit number is suit number NICN BHC/18/2023.
Okay. Your name, please. Your name,
Aja Sylvia, my lord.
Sylvia. Spell your,
Yes, my lord.
spell your surname.
AJAH. AJAH, my lord.
You are for the claimant.
Yes, my lord.
Who is on the other side?
Okay. Okay, she's back.
Who is on the other side?
My lord, it's like he's not here.
Yes, my lord.
But he was informed.
Okay. Okay. So, how was it? How did it go? Oh, okay.
Are they in court or not? Are the claimants in court?
No, ma'am. No, my lord.
All right, so here's the judgment of the court. This suit was commenced by an originating summons which was filed on the 13th day of February 2023 and accompanied by a 20-paragraph affidavit deposed to by one Francis Idigbe, accompanied by 6 exhibits and a written address in compliance with the rules of court. Through the said originating summons, the claimant is seeking for determination of the following questions. I'll skip reading out the questions. Claimant opposes the resolution of the following questions. 6 for the following relief. Please, can you mute yourself? Mute yourself. The defendant entered appearance on the 24th day of February 2023 by filing memorandum of a conditional appearance, accompanied by 20-paragraph counter affidavit and a written address in opposition to the originating summons. Upon receiving the counter affidavit to the defendant, the claimant on the 17th day of April 2023 filed a further and better affidavit of 12 paragraphs, accompanied by a reply on point of law. Arising from the affidavit in support of the originating summons, the highlight of the fact leading to the questions for determination and relief sought by the claimant is that the defendant operates the business of a hotel from which it pays monthly salaries to her employees, and that the claimant introduced the employees' compensation scheme to the defendants through letters and enjoined them to key into the scheme as required by the Employees Compensation Act 2010 for the benefit of its employees. However, despite all letters and pre-action notices served on the defendants failed to comply or has willfully neglected to register with the Employees Compensation Scheme, and also failed or refused to furnish the claimant with its complete and accurate total monthly payroll from 2019 up to date, and failed or refused to make minimum monthly contribution of 1.0% of his total monthly payroll from December 2018 up to date into the Employees Compensation Fund managed by the claimant, and that because of the defendant's failure to comply with the claim, the claimant is imposing an interest of 10% on the defendant's total monthly payroll from December 2018 up to date. In reaction to the foregoing, the deponent posited that the defendants operates a hotel business, but with only 3 permanent staff and 2 other casual staff, who are mainly students and who leave the defendant's employment at regular intervals. And the defendant does not have the requisite number of workers to qualify for it to be part of the Employees Compensation Act scheme, and if the claimants only wrote to the defendants for the first time about the Employee Compensation Scheme in 2022, but that it sought the cooperation of the claimants and all its affiliates, officials, but the officials of the claimants were so unfriendly by their actions and they were not civil in their approach to the defendants. We made it impossible for the defendants to come to terms with the claimant. The claimant countered some of the assertions made by the defendants in their further and better affidavits, and same will be considered in the course of determination of these questions for the court. Arising from the written address on behalf of the claimant, counsel to the claimant Adaku Onwodikwe Esquire formulated 3 issues for determination. I'll skip reading out the arguments of counsel. By way of response to the foregoing, the counsel to the defendant Uche Olawone Esquire, through the written address in support of the counsel affidavit, in opposition to the originating summons, formulated submitted a reply on points of law. I'll skip reading out the reply on points of law. I've carefully considered in great detail the processes filed by the parties, the exhibits attached, and the address in support and opposition of this originating summons before this court. I've also reviewed the